Good morning. Are you Dominic Lee?
Yes, ma'am.
And this is 25 DCCR 1784. Mr. Lee is charged with criminal mischief from October 14th of 2025. What is the announcement?
Judge, I've talked to Mr. Lee about the situation. I've also, of course, have talked with the state. There is some information I do need to check out in regards to probation he had been recently placed on. And some other things with his criminal history, because especially with that probation, I think that may give us a option to try to get this resolved.
A probation here or somewhere else?
That's
Here.
here, Judge. And we spoke about this, but I mean, he's got obviously through the indictment, it's like it bumps it up to a third degree versus what his
Bumps it up to a second.
Second, actually.
But if there's, so, do you show an active? So there would be an MTRP if there was.
I don't have.
All right, I'll reset it so you can figure that out, because if there is a motion, I would assume that there would be a motion to, I mean, if there is a probation, I would assume there would be a motion to revoke. So I'll just do a normal reset to give you some time to get all that worked out. If you'll check into it
I'll
too
check
and
into
see.
it. I did check prior to coming down, Judge, but I don't have that. It's not in our system. So I'm
Okay.
not sure what.
Talk to probation, talk to him more and see if you can figure it out. Otherwise, we'll go forward with what we got when we come back.
Because my understanding is that is kind of what led us, because he was in custody at the time and then was released when he received the probation. This allegation occurred, of course, inside the jail.
The criminal mischief?
Yeah, this occurred all in custody.
Okay.
So,
Okay. Okay, I'll let you guys check on it and see, what it was, and if you got the probation after the incident. It's okay. All right, we'll figure it out. Y'all figure it out. Okay, go back with the bailiff.
thanks.
Thank you. And then, Maribel, is it Raquel? Good morning. Are you Maribel Raquel?
Yes, ma'am.
And Ms. Raquel, in cause number 25 DCCR 0664, you're charged with the state jail felony offense of unauthorized use of a vehicle from April 2nd of 2025. What that means is that if you go to trial and you're found guilty, the range of punishment is between 6 months and up to 2 years in a state jail prison. Do you understand?
Yes, ma'am.
That on the rejection, Judge, there was marked something about proceed only on count one, but that was
Yeah, well,
confusing to me.
I
There's,
just put it at the top.
So is there some criminal history?
There is criminal.
There is. It's just not in the
It's just not
indictment.
In that.
And so what would the criminal history, would it enhance?
No, John, no, Your Honor, but
Okay, but there's enough, but that it would not enhance
When
it.
it is.
So the state has made an offer, I have a plea bargain rejection that you've signed here with Mr. Lewis that shows that the state's offered 1 year in the state jail if you wanted to enter a plea of guilty. You have every right to reject that and have a jury come in and determine if you're guilty or not. And if they find you guilty, you can leave your punishment up to them. I just want to make sure today that you understand what the possible consequences are if you go to trial and what your options are if you wanted to enter a plea of guilty. And do you understand all of that?
Yes, ma'am, I do.
And do you want to reject that offer and have your case set for trial?
Yes, sir.
All right, we'll get that done. Ms. Raquel, Mr. Lewis has been appointed to represent you. He's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him. We can appoint another attorney today who could begin preparation for trial a little quicker. Is that okay with you? Okay.
If Mr. Lewis cannot do it, then yes, ma'am.
And he can. It's totally up to you. He's.
Mr. Lewis.
You would? Okay, so Mr. Lewis will remain as your attorney and begin preparation for trial. All right, you can go back with the bailiff. Thank you. See, Ms. Perazzo, you have Thaddeus McCrae. All right, ma'am, you're Louisa Mcgruder.
Yes, ma'am.
And Ms. Mcgruder is currently on probation for sexual assault of a child in cause number 16-25158. Motion to revoke probation has been, or motion to revoke unadjudicated probation has been filed. And Mr. Bynum, do you have an announcement?
Yeah, if we could confer with the court perhaps, but if we, I mean, we're ready to likely not true and all of that, but I've been speaking with, this is my first time appearing on it.
Sure.
Ms. Mcgruder, if I can just introduce myself and why I'm here. And, little known fact about Ms. Mcgruder is that she's actually one of the class plaintiffs in what is still the largest civil rights case related to bail in the history of the country, in federal court here in the Southern District. So she sued Harris County, the judges, regarding the misdemeanor bail practices. And I know her because I was one of the judges she sued. And, but I agreed with her, which as a criminal lawyer, I don't have much of a conflicts practice, but this was a pretty funny one. The lawyers in that case called me and asked me to try to take care of her here. And what I say about being on an MAJ is that I'm the last to the party. You know, that everyone here has been here on the case for much longer than me. It seems to me that she's, she's 8 years into a 10-year probation and has put down many years of sobriety in there. She's responded successfully to ISF in 2020.
Let me stop you, because I guess just as far as kind of procedurally, if there is, the way I'll handle all of the motion to revoke. So if there's an agreement, y'all can get that taken care of, do paperwork for whatever's going to happen. If there's not an agreement and you want to argue for me to do certain things,
Right.
then what I'd rather do is go through the motion, get pleas of true or not true, and then what I do is reset the case for a sentencing hearing. So everybody has time to provide whatever information they want, bring any witnesses they want. Probation will do an updated pre-sentence report that'll give me more information, and then I'll listen to all of that on that day.
Okay. I understand. Could I just add where I was going with what I was saying, and I'm sorry I'm long-winded. I was wondering if the court would consider, she has a TRAS from last May that recommends substance abuse treatment. I was wondering if the court would consider, with the consent of the state, amending to safety.
So what would happen is I would still get an updated report, because I need to see what all if they agree to that, then yes, I will consider it. So if y'all have an agreed recommendation, yeah, she cannot go because of I didn't think her underlying offense. She's not eligible.
Judge, just to let the court know, and I don't want to interrupt.
No, please.
And the court knows the history with this, but back in June of 24, we did where the court was absolutely will not accept the plea agreement on this.
Okay.
We're not gonna agree to anything because we've done this.
We've been here before. It's unfortunate that I recognized Ms. Mcgruder over the last few years, and so apparently I have.
We've given
So
twice. We've actually given it.
Okay, so
compliance, very strict compliance.
all right. So here's what we need to do then, based on that, just so that we can all get caught up, is get the pleas of true or not true to the allegations, and then reset it for a hearing. You can provide whatever you need, argue whatever you want, bring whatever witnesses, state can do the same. We'll get that updated report, and then I'll make a decision what to do. Okay?
Well, I'll enter pleas are not true.
So let's do this then. Ms. Mcgruder, please raise your right hand the best you can, please. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, thank you. You can put your hand down. And will your client waive the formal reading of the motion?
Yes, we will.
Okay. Let me get this pulled up. So, Ms. Mcgruder, in cause number 16-25158, I have a motion to revoke your unadjudicated probation. It shows that you were placed on probation January 29th of 2018 for sexual assault of a child, a second-degree felony, and that was a 10-year deferred probation. Is that correct? And then it alleges that you violated your probation. Count 1 alleges that you failed to report as directed to the probation department on May 23rd of 2025 and to the administrative hearing on June 2nd of 2025. And is that true or not true? Count 2 alleges that you failed to work faithfully at suitable employment and provide verification of that. Is that true or not true? Count 3 alleges that you failed to submit to alcohol and/or drug screening on June 2nd, May 28th, and May 19th of 2025. Is that true or not true? Count 4 alleges that you're behind in your court-assessed fees as of June 2nd, 2025, in the amount of $8,645. Is that true or not true? And then count 5 alleges that you failed to enter and successfully complete the Jefferson County Drug Intervention Program, JCDI, and that's from the order from September 24th of 2024. Is that true or not true? All right, so I will have pleas of not true entered for all 5 counts. Again, we'll reset the case for sentencing, and I will ask for an updated pre-sentence report. Obviously, anything that you think is important for me to know, get that information to Mr. Bynum. He'll present it to me on your behalf on that date. All right, we'll see you back on that date. Thank you. Good morning. Are you Derek Green?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
Yes, Your Honor.
It looks like we're going on lesser, correct?
Yes, Your Honor.
I'm getting there, sorry. All right, Mr. Green, in cause number 25 DCCR 1119, the state has elected to proceed on count 1 only, and in that count, to the lesser included offense of a Class B misdemeanor terroristic threat from June 19th of 2025. And how do you plead to that charge? And are you pleading guilty freely and voluntarily? And because you did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Smith? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And are you a U.S. citizen? State tenders number 1.
Okay.
It's admitted. Is there any evidence that Mr. Green is not competent?
Okay.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your plea, find sufficient evidence to find you guilty, and at this time find you guilty of the lesser offense of a Class B misdemeanor terroristic threat, sentence you in accordance with your agreement to a term of 150 days in the Jefferson County Jail. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, so you have waived your right to appeal. All right, good luck to you, sir. You can go back with the bailiff. Thank you. Thanks.
Thank you, Your Honor.